So step 4 is to become legally judgment-proof. Now, if you're totally broke, like the folks who sold you the house there with the meth house, where's our guys with the meth house? Yeah, so he's protected. He's dead broke. But unless you want to stay dead broke your whole life, you're potentially targeted. This isn't just for people who are multimillionaires. Because if you're like a Trump, you know, he's got teams of lawyers that could fight and fight and fight. That's what he does. If you're only worth $500,000 or $1 million, you know, a lawsuit could wipe you out. And the legal fees alone could wipe you out. Just fighting it. So it's just as important, you know, if you have a moderate net worth as you do a maximum net worth. So we want to become legally judgment-proof. What does that mean? We want to take advantage of the laws that exist that limit what a creditor can get. Okay? So for example, under the law, a creditor cannot get your homestead in certain states. Except for the lender who has a lien on the house. You waive it as to that lender. So if you don't pay your mortgage, they take your house. But if you had a judgment against you for no matter what amount, and you had $1 million house in Florida that you lived in, they can't take your house. They just can't take it under Florida law. Under Colorado law, it's a little different. You get like, what is it, 65,000 or 70,000. That's it. It means the first 70,000 in equity, they can't take. So if your house is worth 300, you owe 200. The first 65 is protected. If they forced an auction, it wouldn't go for 300 anyway. It'd probably go for 250, so you're probably okay. Does that make sense?
Yeah.
If you own the house free and clear and it's worth $500,000, get yourself a line of credit. And you get sued, you're going to draw that line of credit. And money is much easier to disappear than properties. You went to Vegas, you get 2 tickets to Vegas, stay a week, I lost all the money. And frankly, I'd rather gamble it away than give it to a creditor anyway. But you know what I'm talking about. Pension funds, 401ks, IRAs, generally protected from creditors. So if you have a self-directed IRA and you buy all your bulk of your properties in that, they can't touch that. That's good. You want to fund your IRA or your 401k, whatever it is, they can't touch that. So there's certain things under the law they can't take. They can't take. Now we're going to maximum. And one of the devices we use to maximize that protection is what's known as a family limited partnership. Now, a limited partnership is owned by partners. Like an LLC is owned by what? Members, which is just a fancy way of saying partners. Okay? A limited partnership is owned by partners. We've got general partners who run the show. General partners are in charge. They run the operations. The limited partners are basically put up the dough. Right? They put up and shut up. Has anyone ever invested in a limited partnership before? Yeah, you have. You have. So as a limited partner, you have no liability, like a shareholder in a corporation, because you're totally uninvolved in the management. General partners are liable, though. Are liable. So a typical syndication deal or a commercial project, some developer is the general partner, and he solicits limited partners to put up money, but they have no say-so in the operation of when things get distributed, who gets a dividend and not, what to buy, when to sell, and so forth. Does that make sense? General partners run that. It's great for asset protection because, I'll show you in a moment, that creditors have a hell of a time getting to your interest in the family limited partnership. So let's say, usually what we do is we use a corporate entity, like a corporation, to be the general partner. Now this is particularly the case if you're single. If you're single, you can't have a partner. If you have a spouse, that's easy, right? So if you're single, you use a corporation to be the general partner. That's a separate person from you under the law. And maybe own 1%. And then 99% would be you or you and your spouse. Does that make sense? Does that make sense so far? All right, so the limited partners who have no say-so own 99%, and the general partner who's controlled by who? The husband and wife. But legally it's a separate entity. If the partnership gets sued, general partner's a corporate entity, can't be liable. And the limited partners have no liability anyway. That's if they get sued from the outside in, meaning someone sues the company. What we're worried about is someone suing from the inside out. So they get a judgment against one of these guys unrelated to this business. And now they want to get through the back door and take their interest that they own in this partnership. Yes?
Wouldn't a judge look skeptically on that too if a lawyer just said, hey, this is a sham, and look, the general partner and the limited ones are the
Just
same.
watch. Assets in a family limited partnership are judgment proof. And the way it works is, let's say you and your wife are limited partners and you control a corporate entity, the general partner. And this, by the way, this doesn't matter. You could be a limited partner and a general partner, by the way, personally. You can be both. You could be 1% limited partner, general partner, and 49% limited partner, and your spouse the same. You just have to have two people. So if you're single, you got to use a corporate entity as the partner. Now, let's say someone gets a judgment against husband or wife. They say, this is all we got. This limited partnership, it's got $10 million worth of assets in it. Can the creditor take the assets? No, they don't belong to the individual, they belong to the entity. But can they get through the back door? Like if this was a corporation, just the corporation owning 10 million in assets, what they do is they take the stock and say, I'll take that, have an emergency board meeting, fire you off the board, appoint someone else that's friendly to them, and liquidate the assets of the company. So corporation gives you no protection from the back door, only from the outside in. Whereas limited partnership, under the law, the only remedy, they can't take your membership, your partnership interest. What they get is called a charging order. How many people have heard that expression before? Charging order. A charging order is an order issued by the judge in the case that says it directs the general partner to pay to the creditor what they were paying the partners. So let's say there's 100 grand in net income every year, and every year the partners are taking out the income. Now, like an X Corp, like I said before, if this company earns money, the partners get a K1 and they're taxed on it whether or not they take it out. So you might as well take it out, right? But whose decision is it to distribute money or reinvest it? General partner's decision. Okay, so now the general partner gets a charging order saying pay to the creditor husband's share of income, which is, let's say, 50 grand a year. The general partner decides, I think it'd be a good time to reinvest. Not distribute income this year. Can the husband say anything about that? No. Even if it wasn't a corporate entity, let's say husband and wife were both general partners and the agreement says you need unanimous consent to distribute money. And the wife says no. And the husband says yes. It's a deadlock. No. So if there's no income being distributed, what does the creditor get? Nothing. It gets even better because if they have a charging order, there's income being earned which is not being distributed, called phantom income. That means husband and wife are still getting a K1 form saying this is your share of income, $50,000, even though you never got it. You understand? So who's liable for the taxes on that K1? The creditor. Seriously, the creditor. The IRS did a revenue ruling on this back in the 70s. And they posed this question, if a creditor has a charging order, who's liable for the taxes on the phantom income? They said it would be the creditor because they're entitled to the income. So the point of this is academic. A creditor's attorney knows that. They're not going to try to get a charging order against the limited partnership interest because they know they're going to get with a tax bill. You got it? Yeah. So if you can tell them right up front, like you can sue all you want, but everything at the bottom is owned in a limited partnership and you can't get to it. The attorneys know this. They're not stupid. They know you can't get to that.